All right. Just to welcome you, if this is your first time attending Access to Justice Board, kindly indicate in the chat your name and the organization if you work for, your preferred pronouns, and we would love to welcome you. And I'm sure that the board members here would love to really chat with you as we continue with this meeting. So I'm going to go straight into the agenda. Approval of the October meeting minutes. This has been provided ahead of time. Board member?
So moved.
Sal, move. Second?
Second.
Second, SP. All in favor, aye?
Aye.
All right. Thank you for the thumbs up. That looks unanimous to me. Bonnie, is unanimous as far as I can tell. All right. E-filing and fees. Mr. Terry Price. Is Terry here? Yes, Terry is right. Terry, take it away.
And I see, Francis, in the chat that we do have a new person with us, Candace, from Legal Counsel for Youth and Children.
Thank you, Candace. You're welcome. And let's try to welcome her in chat. Go ahead, Terry.
All right, in the minutes or in the materials for today's meeting is a brief summary of this topic. Many of you already know it, is that the courts of limited jurisdiction were poised to introduce a new e-filing system. Would have been a single system for 300 courts of limited jurisdiction around the state. But the funding mechanism would have been cost shifting onto the users. $5 a shot, basically, for filing. $5 an envelope or packet, they call it. And the court, the administrative office of the court and the Supreme Court were quite surprised to hear that there was concern about this, and even forces that were against this. And so the implementation of the project went on hold, and the AOC put in a decision packet for $2.8 million for the next legislative session to fund this for 1 year. And even if the legislature approves this, it is not going to go into force until July 1, 2022, because it would have to go through the entire session, get approved, and then funded first day of the new fiscal year. So the Supreme Court has asked the Access to Justice Board for information of what is the community feeling about these fees and any kind of problem solving. I think the Supreme Court is in an interesting rock and hard place. Their funding is extremely limited. They were looking for user fees. At the same time, I think we can all agree we don't in this state have require people to pay for their access to justice. So we wanted to put it on the public session for comments. I am also going to put into the chat, I can't do two things at once, my email, terryjprice@earthlink.net. You can feel free to send me additional comments that you have after this meeting, but we did want to hear from the community of your concerns about this.
Terry, Jim, have you shared or can you share the decision package?
I have not.
Do you have it?
I believe it's a public document.
It is a public document, yes.
So yes, I have it in an email someplace.
Okay, might be useful to share.
Okay. And you raised a point in a previous meeting, Jim. It does look to me like it is a 1 year. This is they're asking for 1 year worth of funding. They're not asking, as far as I can tell, for continuous.
That's correct.
Funding.
So assuming that they do hit this year, and it's going to take a robust effort, then they will have to go back next year for biennial and carry forward funding.
Right.
We need input on this. The Supreme Court is asking us to weigh in on this, and we would appreciate if your perspective, because Terry, who is helping us lead the charge on this, is going to be putting together a report that we're going to provide as access to Justice Board perspective on this issue. So getting as much input from providers, from the communities that you serve, and from the people that walk through the doors at your civil legal aid organizations is very important.
Well, I will follow up quite simply and say we have long since passed the point at which the court and the commissions and even the legislature and the Superior Court Judges Association and the judicial associations have embraced the idea of fee for justice, fee for service justice. This is a fee for service justice thing. It's imperative that no fees be charged to users of the court system. We've learned time and time and time again that it creates an obstacle that disproportionately harms, particularly at the CLJ level, people of color and other communities that are that experience disparate treatment in our law and justice systems. If we believe in the commitments that we've made around equity, both economic equity and race equity, we would take a very strong position. You on the board would take a very strong position against the user fee and in support of robust efforts to secure approval of the budget request, particularly given the fiscal condition that our state's in.
Thank you, Jim. While we're waiting for other comments, I'll also add there's a second thing going on, which is that e-filing will exacerbate a digital divide. If we talk about there's never going to be 100% mandate to e-file, but there is certainly going to be a shift to e-filing. E-filing requires a device, broadband, and a credit card, right? And so will e-filing actually, unless the courts do something, will e-filing actually create two different levels of court users, those that have the technology and those that don't? Texas, of all states, has kiosks for self-represented litigants to use so that they can minimize this digital divide. And I have heard of other courts sending out laptops, literally, to people, to potential jurors, so that they can, again, minimize the digital divide. So this raises these issues for us in terms of if we are going to be, because after the CLJ, the courts of limited jurisdiction e-filing is implemented, it's going to then turn to the superior courts and be a superior court issue. How do those states address CC requirements from Kara Masters? I don't know what CC is, sorry.
Sorry, credit card.
Oh, credit card. I don't know. Our state, the Judicial Information Systems Committee that I'm the liaison to, has talked about was not concerned about these user fees because they felt like there would be a sufficiently robust informal papyrus possibility, and that qualified legal service providers also wouldn't have to pay the fees. But I've never understood, actually, to that question, how do you file a motion for informal papyrus if you don't have the wherewithal to file the motion in the first place? So
Exactly.
it does seem to me, I don't know. I can try to explore how they deal with that credit card issue, but I can't even figure out how our state is thinking that that's going to work.
In other words, we are acknowledging you are poor, you are unable to provide, to support the filing of your paperwork. But by the way, we need you to provide credit card information to be able to file any documents.
And as Evangeline Stratton has said, I've seen kiosks at airports that turn cash into credit cards. To Jim's question or statement in the chat, this is about self-represented versus unrepresented litigants. I am absolutely open for information about the word to use. My understanding is that the courts use unrepresented litigants because for them, the litigant doesn't have legal representation. My understanding was also that the community was using self-represented litigants because they were self-empowered. Please correct me if I'm using the wrong word.
In our state, there's really been a consensus to use the term unrepresented because it relates to the status of the person relative to the court. Nationally, for a very long time, there has been adherence to the term self-represented, in large part because of function of inertia and the creation of the SRLN, the Self-Represented Litigants Network. So people use that acronym. Superior Court Judges Association has an unrepresented litigants work group, and we actually had that very substantive conversation, Terry, when at the outset of that work group's efforts.
Thank you, Jim. Again, if there's no other comments right now, Terry J. Price at earthlink.net, feel free to send me your comments. There's a very quick turnaround for the Supreme Court in order for us to give input before their December 1st en banc meeting. So I will be gathering as much information as possible in the next week. So thank you very much in advance for your input.
Thank you, Terry. Terry, could you put your email again in chat because, for those who are just joining? All right. Thank you so much, Terry. Please continue to provide Terry with feedback on that. Terry has been working on this issue for more than 2 years, and he's consumed a lot of his time, but he's so dedicated to this issue, and I'm so grateful to have him on the board to help us with this issue. Thank you, Terry. We appreciate you. All right. Right to Counsel programs implementation. Jim and Philippe Nerb. Jim, you want to go? Okay.
Do you want to start off, Jim, or you want me to start?
I'm going to go, and Bonnie, are you going to let me share screen?
Yeah, you should have it now. Do you see it?
Okay, let me try it here and see. Excellent. Okay, I'm going to share screen. This will be a very brief presentation. You have previously met Philippe Nab. He is the Eviction Defense Program Manager. He is, I think, now 8 weeks in, and increasingly taking over day-to-day operational responsibility of the implementation and oversight of the program. I do want to walk you briefly through an updated presentation that will be duplicated Tuesday afternoon in a hearing before the Senate Housing and Human Services Committee, and on Friday morning before the House Housing Committee as well. So this is the ATJ version of it. Let me do that. Hold on. I will try to get it to move to the next slide. Come on, Jim, you can do this. There we go. So as you remember, the Senate passed and the legislature passed second and gross substitute Senate Bill 5160. Sections 8 and 9 addressed and established the nation's first appointed counsel program on a statewide basis. The charge to us, as we were assigned responsibility for standing up the program, was to provide high quality representation for every single indigent tenant against whom an unlawful detainer proceeding is commenced, whether it's commenced by filing or whether it's commenced through what we call pocket service, which is just service of the summons. We were charged to deliver a plan for full statewide representation by July 22nd, 90 days following the effective date of bill. We delivered that plan on July 15th after undertaking a very rich and multifaceted planning process involving many people from different organizations, different communities, and different interests. We are charged to achieve full implementation within 12 months following the governor's signature, which was April 22nd, 2022. So what did we do? We convened, as I say, a multidisciplinary, inclusive stakeholder implementation advisory group. There were many people. You can find all of the participants on that group by linking to the implementation plan itself, which includes multiple areas of implementation focus, and I'm very pleased to say is driven from start to finish from the perspective of ensuring equity of access, equity of accountability, and outreach and inclusion for communities that are most at risk of eviction and who are going to be most harmed by eviction. We have been working very carefully, consistently, in partnership with the Superior Court Judges Association, judicial officials all over the state, county clerks, court administrators, and community stakeholders. Philippe and I will be undertaking our first site visit next week, Monday and Tuesday, to Spokane, where we're going to meet with a wide array of stakeholders, including representatives from the local landlords association and the local landlords bar. We have contracted with 13 qualified legal aid providers, most of whom are have hired and will support in-house, full-time, dedicated, professional attorneys, staff attorneys, two of whom will be providing contract attorney services in cases involving conflicts of interest that prevent one or more of our contracted programs to be able to represent the tenant. We will have achieved full statewide coverage through this array of resources that we are putting in the field. We were addressing during the course of implementation a number of really dicey questions about when the right attaches and whether and how courts may proceed to hear eviction cases before the Office of Civil Legal Aid has certified the availability of right to counsel services. The Attorney General's Office Civil Rights Division provided us with two very instructive and supportive letters that have been shared with our colleagues in the Superior Court Judges Association, the clerks, and the court administrators. They are generally being adhered to, although there are some circumstances, and we have one county in particular that has decided to ignore the guidance and proceed with hearing cases, even though Oklahoma has not certified that county yet. So we published the implementation plan in July. Between August and November, our legal aid programs contracted to provide services, recruited, hired, developed a training curriculum, delivered a training curriculum, and engaged 65 dedicated RTC staff attorneys and private contract attorneys across the state. In October, we certified the first 25 judicial districts as being ready and available to accept appointments. As of Monday, coming next Monday, we will have certified 32 of 37 judicial districts. Bonnie has this slideshow. You can actually get to a regularly updated spreadsheet that shows judicial district by judicial district, county by county, where certification has issued, where it has not issued. It changes almost on a weekly basis now. We anticipate full implementation no later than December 15th of 2021. And please note that that's more than 5 months earlier than the legislature charged us to do. They gave us a year. We said the moratorium and the bridge are going to expire. We don't have time. Tenants don't have time. So we moved forward and did everything we could. And kudos to our contract programs, who really took the laboring oar in recruitment, training, and now providing support for our RTC attorneys, full-time staff attorneys, as well as contract attorneys. We could not have achieved this really important place and time without them. We've run into a number of unanticipated challenges. We moved from the original concept of regional screening. Now we have the statewide unified eviction defense screening line run by NJP and staffed by 20 full-time screeners, committed to providing 2 working day turnaround on average in review, screening, and referral of tenants for right to counsel services. We've defined and are in the process of implementing a wide range of changes to the legal server case management system so that we have uniform data collection, uniform practices, uniform procedures, and the data gets fed to us directly from the programs, and the programs can feed referrals from one program to another. All RTC cases are tracked separately. That is the information that we will use, and our partners at the Evans School of Public Policy, which is the research partner doing the longitudinal assessment of the impact of the program. When we wrote the original fiscal note for the legislature, which I will say was fully funded, there were a lot of unknowns. We hadn't even gone through the planning process. We now know that there were things that we didn't assume, including the need for building redundancy into the system, the need to build appellate capacity into the system, and a number of other needs. We have told the legislature that we are going to need somewhere on the order of $350,000 more dollars just to get through fiscal year 2022. And the ongoing cost above appropriated levels for 23 and beyond is somewhere on the order of $850,000 a year. That is what Oklahoma has been, will be seeking. And we will be working with the budget writers and the policy leads in both houses to secure that funding. One thing that I'm super excited to report is that the Office of Civil Legal Aid and Seattle University School of Law. Cindy, you're on, so you can share in the great news. We have entered into what we call a housing justice collaborative, designed to create a pipeline of new, well-trained, energized, motivated, and diverse talent to come into this practice area on a consistent and regular basis. It's starting from recruitment by the law school, through placement by the law school, through training by some of our programs, placement into intern and externships, and then ultimately placement into RTC providers. I believe that a press release announcing this will be issued by Seattle University this week. We've all approved it, so I think it's just getting Dean Clark's approval is required. Beyond that, you know how to get a hold of us, and I'm happy to answer, and Philippe and I are both happy to answer any questions.
Thank you, Jim. Any question for, oh, Sal, go ahead, Sal, and then SP.
Thanks, Francis. Jim, just a couple of questions here. One, because I don't know what it is. What's a certified judicial district? What's the significance?
There are 39 counties in our states,
Right.
and there are 37 judicial districts. There are some multi-county districts. And in order for a judicial district to be able to proceed to hear eviction cases involving indigent tenants, they must first have been certified by the Office of Civil Legal Aid, basically affirming that the resources are in place, the attorneys are in place, they have completed the 15-hour training program that we've developed and delivered, and they're ready to accept appointments.
Wow, that's so until they get certified, they could not engage in eviction actions?
That's what we and the AG say. That's not what one judge said.
That is just great and good to know. So on the just one other topic on the unlawful eviction defense screening line, two questions about that, and maybe too soon. I'm just curious, how is that line working? Is there a lot of backlog? Like, you know, it's hard to get on the clear line. Or
it's not clear. It is not clear. People are getting through. I had a judge in Spokane County the other day report to Philippe and me that he had been secretly testing the line 6 days in a row, and each day he got through right away.
That's great to hear. And then what are you doing? What's Oakland doing to get the information out about that line so that people in the public will know about it?
We are doing a number of things, but most significantly, we are using a different pot of money. Oh, here comes Cesar. He can help answer that last question. We're using a different pot of money that we push to NJP. NJP is contracted with Pyramid Communications to undertake a very targeted communications, media, and education campaign. It's targeted on the communities most at risk, most harm, and disproportionately lacking access or understanding of their rights and the legal aid system itself.
Great, guys. I mean, Jim, you know, if I was there, I'd stand up and applaud the work that your office is doing. Francis, I would make one request on this Unified Eviction Defense Screening Line. I know that the Access to Justice Board, we came up with a list. So actually we have two resources, our CAP advisors. This should be getting out to our CAP advisors. And also we have a list of community members that we have contacts. So this number should go out to them. Thank you.
That'd be great.
SP?
Thank you. Thanks, Jim, for sharing that. Very impressive, especially 5 months early. My goodness. I just wanted to know if the presentation that you shared with us, if that's going to be accessible to us, that's something that we could share with the CAP.
Yes, absolutely. Bonnie's got it. So no problem at all.
Yeah, that would make it very helpful and useful. Okay, we'll make use of it. Thanks.
Thank you. Some of the things we do in these states, we have to understand that we are always the first to do it in the nation. so how we pull it off is always a miracle, and it's down to the hard work of the civil legal aid community and the very, very vocal community that's really received these services. They are the best advocates for the program itself. Thank
and I'll
you.
say, Francis, I'll just say, I sent out this morning to the community listserv a link to a half-hour conversation that I had yesterday with Austin Jenkins, much of which focused on eviction defense and the RTC program.
So this has been very helpful. I work with the homeless community in Eastern Washington, and this has been, and the ones we got out pre-COVID, this has been a huge help to them, because the landlord knows that when we say that we're going to be having access to justice on this issue, they stay up, they want to work with us, because they know they cannot just take people out. It's not just those who walk through the door. It's the fact that we get to say that we have lawyers waiting to help us with this issue. That really makes a difference in the negotiation. Thank you. SP, you still have your hand up. Okay. All right. Thank you so much, Jim. And thank you, Philip. This is awesome work. And thank you, Seattle U, for all the work that you're all doing. Thank you. We're now going to move to the next issue on the agenda, which is the Invisible and Inaccessible Young People's Perception of Civil Legal Aid report from SEYC. Candice, welcome. I really need to introduce you, but you don't need much of an introduction. We're so proud of the work that you guys do, and we appreciate this. We appreciate you coming in to present this report today. So over to you, Candice. Thank you.
Thank you so much for having me. I'm really excited to be able to share my project and report with you all at the Access to Justice Board. Aspects of the ATJ's hallmarks, the board priorities, and state plan are reflected throughout. So I'm really looking forward to sharing everything that I learned. And so I'm gonna share my screen and pull up my presentation. Okay, can everyone see it?
Yes.
Yes.
Okay, all right, thank you. And yeah, this is just the title, so I'm gonna dive right in. So I'm not gonna spend too much time on the role of civil legal aid. I know you're all very familiar with our field and what we do. I talk a little bit about the 2015 Washington State Civil Legal Needs Study Update. And I know that that's mentioned throughout the state plan. And through that, we see that more than 70% of the state's low-income households experience at least one civil legal problem a year. And we as civil legal service providers exist to address these civil legal issues that create barriers to basic necessities, safety, and stability. And though we play this critical role, it's uncertain if communities that most need access to civil legal aid are aware that we exist or identify these barriers they encounter as civil legal issues. And further, if they are aware we exist and they are able to see that this is a legal issue they should reach out to about, the accessibility of our services are called into question. And so what did I do to learn more about this? I reached out directly to young people. I did an online survey tool and focus groups. And starting with the survey tool, because I really wanted to hear from young people in King County specifically. That was the requirements for the survey. All the survey participants were between the ages of 13 and 24, located in King County and had experience with homelessness. Another major aspect to my project was hearing from young people of color in particular. We know that people of color are disproportionately affected by civil legal issues and disproportionately affected by homelessness. And so to reach BIPOC communities, I circulated this survey to partners that work primarily with BIPOC young people. Examples like Atlantic Street, they do a lot of housing navigation, case management services. Community Passageways, they do a lot of great work with restorative justice. And Seattle Public Schools Interagency Academy. And the survey asked young people questions about their experiences with civil legal aid and attorneys. Did they know what civil legal aid is? If they had heard of it, what did they know? What had their experience been like working with attorneys? And to engage in those responses and results more deeply, each person who took the survey was offered a chance to participate in a focus group. I held 2 focus groups with Atlantic Street's weekly young parents group. Unfortunately, with the pandemic, it's a little bit hard to get high engagement in these non-essential activities, but I still talked to a lot of young people. They had a lot of great input. And you'll see at the bottom, all folks who participated in both the survey and the focus group were paid for their time and expertise. And so through the online survey tool and the focus groups, I got 3 main key findings. The first, most young people do not know about civil legal services. They're unaware that lawyers can help them with everyday situations and remove barriers that exist for them for housing and safety. The second key finding, when young people do interact with attorneys, the communication between them and the attorney serving them can be frustrating and problematic. And the third key finding was that this strained interaction between attorneys and the young people they were serving was heightened because of attorneys' internal biases and systemic racism. And so over the next few slides, I'm going to dive a little bit deeper into these key findings and then show you all the recommendations. And the first finding, most young people don't know about civil legal services. Of the folks who responded to the survey, and 73% said they had not heard of civil legal services. And that's huge. That's way more than half. A lot of young people just did not know we existed. Of the 27% who did know about civil legal aid, they were asked, so what do you know about civil legal aid? And got a varying of responses. Some of the responses were, well, I've heard of the name, but I don't actually know what they do. We had a lot of misconceptions about what civil legal aid attorneys do. Someone said, oh, they're not attorneys who represent you in court. They just help you find a real attorney to work with. Or if they had worked with a civil legal aid attorney, they had a more narrow view of what the services were. For example, a respondent said, oh, I worked with a civil legal aid attorney to help grab some identification documents. So the assumption was that's all they did. And I saw that in a couple of the responses. And to switch up the language a bit and ask the question differently, all respondents were asked, if there were day-to-day situations that an attorney could help you with, what would that look like? And 100% of the answers were situations that could be addressed through civil legal services. Examples given, trouble with landlords and housing, facing eviction, unemployment, wills, debts, navigating Social Security. And so you could see the need was there, but just they weren't aware of our services. And in addition to not knowing about the existence of civil legal aid, young people indicated they wouldn't know how to connect with an attorney even if they knew they needed one. The top 3 results from young people, about 19% said they would ask family and friends, where should I go? What should I do? But the problem was that often their family and friends didn't know how to identify the civil legal need either, or where to turn for an attorney. Another popular answer was that they would go online and Google one, but young people brought up the issue that they often, especially when they're experiencing homelessness and housing instability, may not have stable connection to Wi-Fi or access to a phone or a laptop. The third most popular answer was that young people said they just don't know what they would do. And that would be the end of it. They would just have the issue and it would hamper their ability to move on. The second key finding was that when young people do interact with attorneys, the communication between them was often frustrating and problematic. All respondents who indicated that they had worked with an attorney expressed a similar sentiment, that the attorney's style and level of communication with them needed much improvement. When asked, what would you like to see from your attorneys? All of their answers were surrounded about showing basic decency, being patient, showing empathy, not being dismissive of what they were going through or the context of their situation, helping to motivate and guide them through their legal situations versus taking control, telling them what they needed to do and assuming they knew what was in their best interest. In addition to the communication itself being hard, young people said that it was even more difficult to just get their attorneys to regularly communicate with them. And absent that consistent communication, respondents didn't feel as supported by their attorneys, like they could confide or trust them, which broke down the communication and often affected the case and their ability to take care of the issue the young person reached out for. The third finding was that about the interaction even being more strained because of racism. And 83% of the survey respondents said that they had not worked with an attorney of their race. Huge, way, like the other number, way more than half, 83%. And 62% said they wish they had, and for a wide range of reasons. Young people said that just when they're in a tumultuous situation, having that support of someone that shares a common background, a common experience would be comforting, to knowing that they're interacting with someone who cares more for them, who wouldn't see them fail, who they felt supported by. 24% of the young people surveyed said that their experience receiving legal services was negatively impacted due to racism. And a lot of young people gave very specific instances too. A Black respondent said that they worked with an attorney who totally dismissed them. They were like, look, I see your situation. I've seen it happen multiple times. There's not nothing I can do for you, and stopped responding to them. A Latinx respondent talked about an attorney who told them they were blowing their situation out of proportion because Hispanics were over dramatic. And those words really stuck with these respondents and stopped them from wanting to continue with services. A lot of young people, not so much a specific experience, but a general feeling was that they were responded to much more slowly than their white peers. They had white peers going through processes quickly, getting better results, but weren't seeing the same for themselves. And these are the 4 recommendations that came from those 3 key findings. All of the recommendations were also from the young people who took the survey and who participated in the focus groups. And the 4 recommendations: first, make civil legal aid more visible and accessible by increasing community engagement and partnerships. 2, strengthening community knowledge around civil legal issues and resources. 3, increasing intentional learning for white attorneys. And 4, diversifying civil legal aid with attorneys of color. And so now I'm just going to dive into all 4 of these a little deeper. And the first recommendation, you'll see a lot of this reflecting actually in the ATJ's hallmarks. I know the hallmarks talks about access to services and the duty to identify and eliminate barriers. And so the first recommendation, making civil legal aid visible and accessible and increasing community engagement. Like I mentioned, more than 70% of the young people said they did not know about civil legal aid at all. And so to improve this visibility, what they suggested was we have to engage with trusted community partners and conduct outreach in youth-friendly ways. And they said a great way to do this is to just show up where young people already are. I know we often do show up in like schools or other service provider agencies, but young people recommended we think outside of the box. If we help with things like debt, why don't we show up more like banks? If we do things with like libraries, a lot of people go there after school to study, show up and hold regular sessions. And that was another thing, making these presences more regularly. Young people don't know when they can expect to see a lawyer at an event. It's a very rare circumstance, and it feels kind of scary to them, like, oh, a lawyer, what's that supposed to mean? And alongside improving the knowledge of the existence of civil legal aid, we have to make services more attractive to young people and accessible to them. It's really hard for young people who are experiencing homelessness or housing instability to take time off a job to meet that rigid afternoon schedule of when services or intakes are done. Or it's hard for them to get transportation to go downtown or wherever offices are located. A lot of young people indicated it's been easier to find help during the pandemic because of the flexibility of virtual services. And that's something they'd like to see continue. The second recommendation, strengthening knowledge around civil legal issues and resources. And this came up, I saw in the state plan, about increasing access for underserved and underrepresented communities and providing clients that legal education they crave. And so along with expanding partnerships and outreach for civil legal services, there needs to be regular opportunities for community-based legal education and self-advocacy. And I talked a little bit about this in the first recommendation, but young people said they want to see lawyers in the field more often, making their presence known. And if we are partnered with communities they trust, who can vouch for us, and they demystify what it means to reach out to a lawyer for help, maybe before crisis strikes, like, I see I'm having a problem with housing. Let me address this before it turns into a barrier and I'm on the streets. That's something they wanted to know could be possible. A lot of young people noted social media was a great tool to share information because virtual tools and resources can be accessed on their own time. And I mentioned this a little bit too with the first recommendation, putting things online because it's easier to access. Like, I can go online and say, oh, I have an issue with eviction, or I have an issue with debts. I know that LCYC put out a video about that. I can look it up, identify my issue, and know to reach out to them. They say it's really hard because a lot of the times legal fields put on long, hour-long sessions that they have to come to at a certain time, and they're like, we can't do that. Make it short, make it quick, tell me what I need to know. And young people identified a whole range of civil legal issues they want to receive education around. When I first did the survey, I mentioned young people were asked, what day-to-day issues would you like to receive help with a lawyer from? And they listed a lot that they did not know a lawyer could help with. And in the focus groups, we talked a little bit about what civil legal services are, and all of these different topics came up. Young people want to learn about expungements, parent rights, unemployment, emancipations, identification debt, theft, obtaining legal documents, immigration, police issues, debts. They are more than willing to tell us what they need to know, and they just want us to put it out there for them and help them go through it. The third recommendation is increasing intentional learning for white attorneys. And we mentioned a little bit before about the dynamics that young people have seen when they've reached out for help. And oftentimes they're working with white attorneys, and it's not like they don't want to work with white attorneys ever, but they want the white attorneys they work with to be culturally aware and responsive in their engagement. And this is more than just sensitivity trainings, those formal, oh, we have to learn about DIE and diversity, but really going out into the community and showing support. Examples given were, why don't we see attorneys show up at Juneteenth festivals to show that you're really there for not only when disaster strikes, but you're supportive of the community. You're there to celebrate wins, and you're someone that they can trust. And I talked a little bit about these second and third bits in that statement. Yeah, young people want to feel comfortable working with attorneys who don't share their race, and that these trainings around sensitivity and race cannot be a substitute for really showing up and listening directly to young people and organizations led by BIPOC leaders. And the fourth recommendation is to diversify the civil legal aid field with attorneys of color. And I know this was a huge part of the state plan in promoting and fostering race equity. And what we see in the field and what we see in both the field of homelessness and the civil legal aid field, people of color are overrepresented in the population of people experiencing homelessness and underrepresented in the legal community that exists to serve them. The lived experience that attorneys of color, particularly Black and Native and Latinx attorneys that we bring to the civil legal aid field is invaluable in connecting with and serving youth of color. And civil legal aid must be active and intentional in recruiting and maintaining attorneys of color by creating an accessible environment for them. And that includes things like pay, with making it more attractive to attorneys who come with debts and other responsibilities, because as we've seen, working in a field with lower pay is a privilege. And I'll stop there. Thank you for listening, and any questions?
A question from Cindy is, can we get a copy of this presentation?
Yeah, I can, once I stop sharing the screen, drop a link to it in the chat.
Okay, SP, go ahead, your question.
First, let me just say, wow, that's impressive. Yeah, so your last point, in thinking about the youth and their desire to have attorneys of color, and the challenge that the pool of attorneys of color is not very big. So what kind of conversations that you all have about that? Because try as we may, can't, there aren't as many as we would need, right? So any conversations about that with the youth?
Yeah, tons of conversations, some with the youth, just some with folks that I know in the field on what can be done. And I think a big place to start with that, and something I think ATJ could help with, is not only advocating for more attorneys of color, but collecting the data on what attorneys are already in the field, because we really don't know. While I was writing this report, I find it so difficult to find those numbers. The closest I could get were the WSBA numbers, which show like 2.4%, and this is of all attorneys in Washington. 2.4% were Black, 2.6% were Latinx, 0.8% were Native. And out of all of the attorneys in Washington who work in civil legal aid, that number was 1.6%. But the combination of those numbers just doesn't exist. And so to take inventory of who is providing these services and measure against the communities we serve to try and reflect that. But I think, like I said, it starts with pulling the numbers, seeing who's there, but then also finding out what's stopping people of color from coming into civil legal aid. Why do we only have 1.6% of attorneys working in this field? And a lot of that I touched on a little bit towards the end. It's pay, it's training, it's recruitment. What do these processes look like, and how can we reform and revamp them?
Thank you, Candice. That's very important point. It's not just to hire, but also to retain,
right?
To prove programs in place to ensure that they stay and they don't run to California. Sal, quick, thank you.
Candice, could you quick share your screen so we can see everybody's faces again?
Oh, yeah.
One, I just want to say, I know you've seen this in the chat, and we certainly did a lot of presentations, and I just want to say thank you. So well organized, and I could understand all of your points that you're making. Very thoughtful presentation. So I just want to say that you really did a great job, and you should know that. Two, just quick questions. How many kids responded, were part of that survey? How many respondents were there?
I got 60 respondents on the survey. 60?
And on the focus group, how many people?
Yeah, the focus groups numbers were much smaller. Like I said, COVID really impacted folks' ability to participate, but I had about 5 in the focus groups.
And then I'm just curious of the, I guess the 60, because some of them obviously could not get attorneys and some did. And I should just say this as well. I'm not surprised at all by the findings. I'm still disappointed, but I'm not surprised. So how many of those had attorneys?
I don't know it off the top of my head, but I did pull all of those numbers and put them in my report.
Okay, great. Thank you. Finally, yeah, these problems that you have identified, I see them, and hopefully maybe the ATJ board, we've discussed this, can put together a work group to help work with LCYC on addressing some of these. Some of these are huge. I mean, having enough attorneys of color, the legal profession does a horrible job as is. And at least my thought is one of the reasons, and we actually started a program with my firm at a local elementary school, is because just kids don't know they can be lawyers. Kids of color don't know. They don't have any role models. So it's very systemic. It's a huge problem. But I want to thank you for moving the ball forward once again on these huge problems.
Yeah, thank you. I'm so happy to have the space to share. I've seen that same issue even going through law school and being in the field, showing people we exist, we're here, this can happen.
I thank you so much, Candice. I hope you are going to be available to be able to work with or be part of the work group that may have to focus on these, and with SCYC to be able to help us find a path to addressing this issue.
Yes, please reach out to me as soon as things happen and I can be of service. I'd really like to see this move forward. Happy to present and give any more information that I need.
Thank you. Thank you, Jim.
Thanks again. Great report. I was really stymied when I first read it, when you guys first published it. Couple of observations. Many of the observations that you received generally relative to civil legal aid are the same observations that we see from children and youth in the child welfare and dependency systems, who are disproportionately of color, and the attorneys who are providing services are disproportionately white, and they don't understand the culture of youth, particularly young people. They need to be trained specifically on it. In our space, we have comprehensive standards of practice, which include cultural competency standards and equity standards. The standards of practice are currently being revised, as LCYC well knows, and they need to be directed substantially in greater part by the youth, who are the essentially the consumers in these cases. My question is whether outside of the child welfare system, it might be helpful to have kind of youth-driven standards for legal engagement with young people in civil matters. And of course, the development of training for attorneys working with young people in civil matters. I think it's one thing to say people need to change their behavior, people need to change their expectation, but I do think it's incumbent on us to develop the tools, make sure that those who are engaged in this work have taken advantage of those tools and are accountable to their clients. The only other observation, I threw it in the chat, is next steps. Is LCYC taking the lead on developing an action plan in response to this?
That's something, the next step is going to be on the public section discussion of the ATJ board, hopefully next month. We're not going to let it drag. And I hope that the executive committee, the executive committee should have devoted more time to this presentation than we did. But Church, I want to tell everyone that we're going to be going above, beyond allotted time today. I apologize. And I really deeply, deeply apologize to everyone. Church, quick.
Sorry, just real quick. Candace did a great job. LCYC, I don't think at this time is going to take lead. We don't have the capacity. The reality is we are on the ground serving clients. If we had funding, we could consider it. But I think we would be, I mean, Candace can obviously help, but we cannot take lead. The other thing I wanted to mention as far as child welfare, while it's great that there's more training, in King County right now, we only have 2 Spanish-speaking attorneys, and they both work at LCYC. It's a massive problem. And it's not enough to say we are just going to, the pipeline's too small. It's not. We have Spanish-speaking attorneys. Look at the rates that people get paid. It's a major problem. We do it at a loss. We do not make money on it, and it's not a livable income. So if you want to talk about that more, happy to talk about it later. Sorry to take so much time. Thanks, Francis.
Thank you, Church. We are going to continue this conversation. SP, okay, thank you. All right. Northwest Immigrant Rights Project report. Can we get, Malu, yeah, there you go. Take it away. Thank you.
Thank
Good
you,
to see you.
everyone. Good to see everyone. And thank you for inviting us to come back and report back about what's going on with us. As you know, Northwest Immigrant Rights Project has 4 offices across the state. We continue to be working mostly remotely across our 4 offices. We are close to the public unless an appointment is scheduled. As you may suspect, the deadlines continue, the requests for more evidence continue, people continue to be placed in deportation proceedings. In fact, people continue to be placed in immigration jail, detained in Tacoma. So the work is as it was before. The change in administration has not necessarily changed the impact, the negative impact that it has in our communities. So I wanted to just talk a little bit about an update that we have internally as we continue our remote work. We have been also able to provide our services in more innovative ways. One example is our DACA portal. For those of you familiar with the Deferred Action for Childhood Arrivals, DACA, for youth who came to the US before turning 16 years old. DACA has been challenged by the previous administration. Fortunately, the Department of Homeland Security continues to accept applications for renewal. So we are helping clients across Washington State through this new portal that we have, and I'll add it to the chat in a minute. But the portal consists of general information and resources for people who are eligible to renew their DACA application, information on the renewal clinics that we provide, and registration for the clinics. I also wanted to talk about a little on some funding that continues to impact the immigrant communities here in Washington. You may have heard about the Seattle Council, Seattle City Council voted on, or is voting on their budget. The mayor reduced the budget for the Legal Defense Network, but fortunately, the council added the full amount back to it in their balancing sheet. And this is especially important because this program, the Legal Defense Network, which was established in 2017, was created to help people who are facing deportation proceedings, so are potentially going to be deported from our communities. And this particular funding or network is facing a surge in demand due to the current Biden administration's decision to implement a dedicated docket. Not sure if you have heard of that, but it's a program across 11 cities, and Seattle is one of them, to expedite the cases of asylum seekers. These are families and children who came to the US, were apprehended after May 28, 2021, and are being placed in this fast processing or expedited process for deportation. What's very impactful is that in the first 4 months of this policy being implemented, we have about 900 people out of the Seattle Immigration Court. And the implementation of the dedicated docket does not include any funding or added federal programs to ensure that the families who are going through these processes will have access to legal representation before the immigration judge. And current data actually indicates that about 85% of the cases pending in the dedicated docket before the Seattle Immigration Court lack legal representation. You may know that in the immigration context, there's generally no right to counsel. So we are seeing people being ordered deported. In fact, one example of a case, we saw a family who had received 2 notices to appear, one before the Tacoma Immigration Court, which only served detained people, and one before the Seattle Immigration Court. When they missed the Tacoma Immigration Court hearing, they got order removed. So they came to us and they're like, but our hearing is in Seattle. And we were trying to figure out how to handle this particular case. So, yeah. Do you want me to stop? I can stop. Okay, sorry.
I think what we're going to do, because of time, what we're going to do is to have you back again next month to provide more report. But we've missed out on report from NAWA for so long that the executive committee decided to at least have you make some presentation today. And so we would love for you to come back again next month to continue with the report. Is that okay?
Definitely. Yeah. Thank you so much. Thank you. Nice seeing everyone.
Thank you. Okay. Because of time, Will said there is no report. Cesar, my notes say that Cesar might not even be in attendance, but you are here. No report. Is there any report?
Federal funding is up in the air. There's a big divergence between the proposed House budget and the Senate budget. It's like an $80 million difference. We are hopeful there's going to be additional funding. On the other hand, we've just recently received notice just this week that the required every 3-year census recalibration is going to result in a funding reduction for based on the formula for next year in any event. So it's just totally up in the air. We don't have any idea what the number is going to be. That's all I got.
Thank you. Kathleen?
Yeah, just really quick, a couple of quick things, mostly dates to be aware of. Our partnership grants, the 2-year grants that our board will approve, that happens next week, and notification will be sent out to grant recipients as well as the Alliance before Thanksgiving. In addition to those 2-year grants, we will announce a series of special grants and our race equity grants from the last cycle. Just mark your calendar. The Gold Mark lunch is Friday, February 11th. And as you know, Annie Lee will be our Gold Mark Award recipient. And Dr. Ben Danielson is our keynote speaker. So we're really excited about that. And finally, I just want to thank the ATJ board members for donating to the campaign this fall. We really appreciate your personal commitment to civil legal aid as shown by your own contributions to the cause. So thank you.
Thank you. We're going to take liaison report next month. Again, I want to apologize to everyone for going beyond time. And it's just because of the choked up schedule that we have. Hopefully, end of the year is always difficult because everyone needs to report before the end of the year. So I hope you understand that this is not meant to extend this long and that you will forgive the executive committee for setting the time like this. So we'll see you all next month. Thank you so much. The notice of meetings is under the agenda. Next meeting for DISCO is 4th Monday of every month. There's a change in that. Tech committee is 3rd Tuesday every other month. Rules committee is 3rd Tuesday every other month. See you all in December. Thank you for coming. Bye-bye.
Thank you.